Right, good morning, everyone. Welcome to the latest edition of the Power Hour with the NAJ. My name is Steve Ennis. I'm the facilitator for the JBN, a group of indie retailers from across the NAJ. And we come together once a month to discuss issues that arise that might be of interest to all of the membership of the NAJ. Today, I'm absolutely delighted to be joined by Michaela Cusack from MBR. MBR are approved service providers to the NHA in the provision of intellectual property protection. So that in the next hour, what we're going to explore is to demystify what it means to have intellectual protection for your business. It's different components, it's different benefits, and the issues that might arise that you might want to consider as an independent retailer. So, Michaela, it's lovely to see you. Thank you for joining us this morning here at NAJ headquarters in Birmingham in the Jewellery Quarter. I understand you've got a long career working in this region pre-MBR.
Yeah, so it's been 2 years since I was working here, but prior to that, I've been here since 2009. So I studied at the University of Law in the Jewellery Quarter, and then when I was in practice as a solicitor, I practiced in the Jewellery Quarter on St Paul Square. And then MBR's office was in the Jewellery Quarter for a few years, so it's nice to be back this morning. Thanks for having me.
Very good. To our audience this morning, if you've questions over the next 40 minutes when I'm in discussion with Michaela, please fire them into the chat and we'll answer them as we go. Otherwise, we'll get to the end of the conversation and then we'll open it up for questions at the end. But if you feel it's an urgent question you want to ask, please ask it. But we will cover all of the questions that we encounter. So back to you, Michaela. So you're the director of MBR. Would you tell us and the audience a little bit about who MBR are, how long they've been around, who they serve, how many clients you got, that kind of thing, and the kind of support service that your customers enjoy from your business?
Yeah, of course. So MBR has been trading since the 1980s, so over 40 years now. My husband and I acquired the business in 2020, so working up to 6 years. Our background is that I'm a solicitor by trade, and my husband's an accountant. He worked a lot with those businesses that were looking to exit on mergers and acquisitions, and was finding that every time IP was coming up time and time again. Mm-hmm. Those that had thought about IP was included in their growth strategy. Those were the business that sold quickest, sold mm-hmm. for the most, had the most value. The investors were there. And then we really value IP. NBR was up for sale. The previous owner was looking to retire, and so that's when we acquired the business.
Brilliant. And you serve how many customers presently?
We've got about 3,500 customers over the UK at the moment. We also work with other IP specialists globally, work together to make sure that our clients' brands aren't vulnerable. And we cover everything from a single sole retailer up to global retail brands, and our products and services that we offer are tailored to their needs and the commercial viability of that. What's important to them? What do they need to make sure that they're not vulnerable?
So it's with a degree of relief on my part that we've got an expert in the room on all matters intellectual property. Now, the next 40 minutes, what we're wanting to do is demystify the subject area that is intellectual property and make it more accessible to everybody within in the NAJ, where you can make informed choices around the level of protection that your business might need. Now, given it's the jewellery industry, this business is made up of a great deal of creative design, unique ownership of the rights to your product and your brand and your trade name, etc. So from your perspective, tell the audience, tell me, if you will, Michaela, the things that the jewellery sector ought to look out for around things like trademark, registering designs, customer recordals and contracts. There's a whole raft of considerations that are especially important to this audience. So let's start, if we may, with trademarks and why that is something everybody should give thought to.
Yeah, so like you said, this is a really IP-rich industry, and some of the most important aspects are those formal mechanisms to record the intellectual property, and trademarks is probably the most well-known really of those marks. So a trademark would give you exclusive use to a name. It might be a brand, it might be your business name, your logo. It may be a product line that you're developing, and you would register that mark in the jurisdictions that you want to trade in, but also you manufacture. It's important to make sure that you're covering where you manufacture your goods as well, and in the classes, the industries that you want exclusive use. So you would register a trademark, and that would last 10 years, and then you can renew that. There are fees that are payable every 10 years, but that would give you exclusive use of that mark. And that would mean that you're in a really strong position to enforce any infringement. You are the owner. You don't need to prove that it's registered. It's a registration with the Intellectual Property Office. And for those businesses that customers are buying from you because of your reputation, you've got a loyal customer base, your name is helping those sales, that's when a trademark's really important, when your reputation is key. Because if someone is trading under a very similar name with a very similar logo, if there are confusion that's happening, if there's going to be some brand dilution, that can be really harmful in terms of revenue. But reputation in this industry is everything, isn't it? So it's really key to have a strong foundation there, and that's where trademarks would come in.
So the protection is in particular important around generating trust with your client audience. So if somebody were to put a trademark on their business, how should they exhibit that so that the customers can see that they are trustworthy and that they're doing business with that brand is something where they're certain that that's the business they are doing business with. For example, on the internet, there could be all sorts of obfuscation where another business might pass off as one that's more reputable. So how should they exhibit that?
So things like names, logos that are registered as a mark. Once you've got a mark registered, you're able to exhibit the R in the circle that you might see that's registered. Sometimes you might see a TM. That is when a trademark isn't registered, but it's being used as a trademark. It's a bit of a warning sign. We're using this as a mark. Don't copy us. But you're not able to use that R unless it is a trademark. It's an offence to do so, and that's really where you can see whether this business that you're working with is the genuine business. There is a quality that comes to it. It's almost an assurance that it's a certain quality if someone's registered their mark and you're clear that this is the same. This isn't just a slight change of wording or a different rebrand. You're able to check. It's a register. The Intellectual Property Office has a register. You're able to see the owner, and there are the marks that are associated with.
And you said it's £700 plus VAT for 10 years. So, I mean, the cost is relatively low across a 10-year time frame. What additional costs might there be to protect a trademark across that 10-year period?
So the £700 plus that would be if you were instructing us to register the mark for you. So that would include the disbursement fees of the Intellectual Property Office, our fees of undertaking that work, and includes the first year monitoring. So we would monitor the Intellectual Property Register to see if there's anyone that's trying to register a mark that's the same or confusingly similar to yours. Would alert you to that fact, and then you can make a decision as to whether you wish to oppose that, or you're happy in that coexistence. That's your call. So that's that fee. You're able to register trademarks direct yourself. The only thing with that is it's so advisable to get some IP advice early on, to know what's available. Is that word able to be registered? Is it distinctive enough? Has that logo already been registered? To have someone that is making these applications day in, day out, it really puts you in a strong position. And like you said, 10 years a trademark lasts for. We offer monitoring services, so that's a cost of £200 per year per trademark. The first year is included, but that would be an additional fee if you wanted someone or us to monitor your trademark to make sure there's no one coming into the market that's a bit too close to you. You can oppose in good time. It's much quicker, simpler, less expensive to oppose an application rather than to
deal with it after
to do it once it's been.
So to the businesses that are watching this webinar, what time in their existence should they consider getting a trademark? Is it 5 years in? Is it, when they've reached a certain level of turnover? When should they get their trademark organised?
I think lots of businesses feel at the start they haven't got the headspace to look into this. They think that IP is really complex, it's really expensive. They don't feel they've got anything worth copying. The value, that they don't see the value yet. And I think once your business starts growing, once your reputation starts growing, as you grow, your IP is exposed, and the more you grow and the more successful you are, the harder it is, the more difficult the position is. So the earlier you're able to just think about your IP, the better, because if you're thinking about your IP, you're thinking about your next design, your next line, you can have the clearance checks done, but beforehand, before it's out there, it's launched, it's in the public. So you know whether that is available. Without doing that, you are launching and you're not aware whether you're already infringing, and that sets you back so much. So to just have IP in your mind from the outset, is this name I'm choosing available? Can I protect it if I want to? When am I going to protect it? Is this design distinctive enough? Is this a new design? Is this available even to be protected? Having those thoughts and just having IP as part of your strategy really supports your growth right from the start.
Yeah. So I think the message is clear. The name on the door of your store is the single biggest asset you have in terms of the connection with your customers. And so it's really important that you have meaningful protection so that you can get on with the business of growing your business, safe in the knowledge that you're not going to be infringed in terms of that brand asset that you've worked so hard to develop and generate. But that's not the only IP protection you can get. There's also a whole industry of people out here who are making and creating jewelry that is bespoke and individual to their business that might carry names and registered designs. So there's a whole field of protection here that doesn't just say the name on the door of the store, but the actual products that are being designed by these highly creative professionals. So what should people do around registering design protection?
So designs aren't necessarily a straightforward area. You've got unregistered designs, you've got copyright, you've got registered designs, but what is really clear is your strongest position is registering those designs. So if you have signature pieces, high value pieces, you are in such a better position to enforce any rights if those are registered. You don't have to, you're not having to prove that you own them, that the originality of them, the date of them. That's already done. The burden of proof is shifted once you've registered them, and that will be protecting the appearance, the aesthetics, the shape, the configuration. If you're not in a position to register a design, it might not be commercially viable for everyone, and also the registration needs to happen within 12 months of it being in the public domains. And for some, that will have already lapsed. The NAJ have a deposit box scheme where you're able to lodge your design, unregistered designs, and that is lodging your design at that point in time. And that is helpful for the evidential burden, because without that registered design, the evidence, it's really heavy on evidence. It's hard to prove, so that can help that aspect.
Again, the encouragement here is that get the protection first before an infringement occurs, because it's significantly more easy to manage where you've got the protection in the first place.
Yes, and for designs, it's time sensitive. Trademarks aren't time sensitive. You can be in business 5 years and decide now to register the name on the door. But for designs, it needs to be in that first 12 months.
Yeah, and I guess there's an issue around burden of proof if you don't have it. Is there something there?
So if you once you use these formal mechanisms, trademark, registered design, the burden of proof shifted. You're no longer on the back foot having to prove that this is yours, you created it, this is the evidence that you're building, you're building this goodwill. It's already known that you're the owner. It's already known that that is yours, and you've got exclusive use to it. You've got the monopoly on it, and that really eases the burden.
And you touched on something when we spoke earlier about it's especially important where there's a visual differentiation of a product, so that something that might be recognizable to a given business and a given product style, that's where it can be really valuable, and protect the owner.
So if there's something that customers are seeing on a design and they know that's associated with you, that's when it's really important, because once others start using that, it's lost. It's lost, and that what makes that design unique and what associates that design with you. It's those aspects. It doesn't have to be the whole product to be new, but there might be something within the design that's unique. That's unique.
Yeah. Cool. Okay. And in terms of cost of protection for that, what might a business owner look at?
If you were to come to us for registration, one design in the UK in one class is about £300 plus VAT. There's a fee payable then every 5 years. It's slightly shorter than a trademark. But if this is a design that you're going to be using time and time again, this is a high value, this is a really popular design, it's worth having that registration.
Now, something I'm less familiar with is the next one we're going to look at, which is customs recordals. This is a bit niche, but if you might just explain how this might be relevant to some of the members of our audience today.
So for those that have already registered their IP, so regardless of having formally registered IP is there, intellectual property is yours, you own it. But if you have registered IP, you are able to also register those marks with customs, with the border force, so that any imitations, any copies can be seized at that point. You're not waiting for them to enter the marketplace, and there is a process to follow for that. So that can be a really powerful tool for some that are really concerned about imitation and copies flooding in. You're able to register your marks, your designs with the border services, and they're able to seize them, destroy those before they're
reaching the market. Yeah. Which again is prevention is the best cure.
Absolutely. Yeah.
Cool. And finally, in this space, tell us about contracts and how they might be of value to the independent retailer.
So one thing we've noticed working in this sector is that sometimes businesses are really proactive in terms of making sure they've done the clearance checks. They want to file, they want to monitor, but there are ways that IP is left vulnerable, and that can be through not having IP in your mind, from the start. So things like non-disclosure agreements. Are you working with others? Are you working with contractors? Are you working on a new design with someone, and have they signed an NDA? We found that some business owners have been working with suppliers, contractors, others for years. They're almost embarrassed to ask. And that shouldn't be the case. You are protecting your most valuable asset. And I think if you were asked to sign an NDA, your thought would be they're backing themselves. This is important. There's no hesitation. If a supplier's not going to sign an NDA and work with you, do you want to work with them? Be someone that you want to continue working with. To be confident in that arena. What are your contracts that you are signing up to, that you're asking others to sign up to? Are they silent on IP? What do they say? Has the position changed? So that is a way that IP can be left vulnerable, that sometimes can need a bit more thought.
Yeah, and again, it's just safeguarding in every relationship. The relationship with a partner might be very good for a few years, but if that goes south, your business is protected, notwithstanding the shift in relationship with a partner supplier.
Yeah, absolutely.
Yeah. Okay. So let's move on from there and into the question around. So there's a lot of misinformation around what people believe is protection that they might have that sits outside IP registered protection. So oh, it's okay. I don't need IP because I'm registered with Customs and Excise, I'm HMRC and so on. So there's a whole range of things that the audience might believe they're covered with protection, where it's actually not the case when it comes to pass. So could you maybe just walk us through some of those areas of examples and tell us what the risk is?
So I think a big misconception is that you have your business registered at Companies House. So you're covered, you own it, it's yours, no one else can use it. And that isn't strictly true. That is an administrative process. You do want that adds to your IP, but registering at Companies House doesn't give you exclusive use. Registering a trademark and registering with the Intellectual Property Office would give you exclusive use. So Companies House will allow a similar sounding name. They will allow your exact business name plus an extra word on. So that might not be the position you want, or so you need to be mindful of that. The same as with a domain.
Yeah.
Someone may register a brand trademark the same as your domain, and you might be prevented from using your domain as a consequence from it. So that is a misconception. Domains and Companies House don't give you exclusive use. They add to your IP portfolio, but those aren't the tools that you want to stop others using the same name.
Yeah.
The other difficulty is there are unregistered rights, and you can rely on passing off. But as we've already touched on earlier, it is really evidence heavy. So for passing off, you're having to prove that there is goodwill, that there's misrepresentation, that damage has been caused or is going to be caused because of it. It's very evidence heavy, and that can be really tricky for a early stage business to prove.
And the reality of that impact is it's burden heavy. So that means you're going to get tangled up in paperwork. You're going to get tangled up on time and cost. So there's a whole raft of bad outcomes involved here, where it's not the field of expertise of the audience. They're getting into a legal quagmire where they may be right, but because they haven't got protection, it basically doesn't matter. And they're going to find it's costly, time consuming, and very difficult to prove in a court of law.
Yeah, you're in a really weak position enforcement wise with unregistered rights. It's not to say that it isn't a safety net, but it's not a strong position, and it's slow, it's uncertain, it's hard, it's a harder position to be in. So it is there, but if you are able to register the things that are most important, the most value, it's just strengthening your position.
Yeah, and we talked about this earlier, where if you haven't got IP protection in all of its forms, the best day to get IP protection going forward is today, so as to negate the risk and exposure that your business might have going forward. So to have it is valuable. To not to have it is okay, but make a decision to get it, and maybe consult with the likes of Michaela's business and MBR, because you'll get the right kind of advice where your needs will be met, and only your needs will be met, not where you get a bundle of products and services that are more than your requirement. You'll just get a tailored response. So to not have IP protection in place can be the reality for many, but to get it going forward, start today and protect your business.
Yeah, I think if you're able to sit back and just do a bit of an IP audit, what do you have? What intellectual property do you have? What creations do you have? What names, what product lines, what designs, what agreements do you have in place? List all of the contractors that you're working with, all of your suppliers. Just look and see, where is your IP? Who owns it? Has it been assigned to you? Those kind of things. Just look and see, and then we offer a free consultation for NHA members. And yeah, we can just maybe advise on the best way forward.
Mm.
Not all types of IP are relevant for all businesses, and not every type of IP needs to be registered. But a signpost in the right direction can be really helpful, especially early days.
Yeah. And beyond names and brands, what other ways have you seen IP exposing and damaging businesses? It's usually in that sort of people-oriented space where this thing that we touched on earlier, relationships not going as you'd hope, or third-party suppliers being in possession of information that could be seriously damaging to your brand. So what steps should a prudent owner take to mitigate such risks?
So this is the contracts point again, I think. So things like having NDAs in place for new products, new lines. If you're having a new mold prepared, those kind of things, you don't want leakage there of your IP in that way. What are you being asked to sign up to in terms of supply agreements and terms and conditions? What are you asking others to sign up to? Quite often collaborations are quite popular, I think, in the jewelry industry, and also you work with people that others work with. If someone's got a really good reputation, you want to work with them too, but without formal contracts commenting upon the IP position, there can be slight movement. So if you're having someone design a particular new line for you, and there isn't a formal agreement of signing over that IP, the designer really has the copyright of it. They would be free to resell that, to work with someone else with that. So you want that assigned over to you. That's part of the work done. There sometimes is an assumption that because you paid for the work to be completed, you own it, but there needs to be a legal recording of that. If there's a collaboration, is it a joint venture? Is there a joint venture agreement? Who owns the IP? Who owns what? How can it be licensed? Who gets the royalties of this? How does it go? Employees are quite often covered with your contracts. If an employee creates IP within the course of their employment, that is owned by the business employing them. But that isn't the same if there's a contractor. And we work with consultants for years at a time, but your agreement with them might not mirror that, and they might work with another business in the next 5 years, and it's what they can take with them and what they can't that we really need to think about. That
needs setting out in a legal format,
and then everyone knows where they stand.
Cool. I think at this point, what we might do is open up to our audience if there are any questions. I think there are. So Sarah might help us here. So can you put a trademark without registering? Is a question from Ali.
So you're able to put TM next to something that you're using as a trademark, but you haven't registered it. Do not put the R, because that means you've registered it. You can put a TM, and that often is used by people that are trying to register, so that the mark that they're using might not be distinctive enough to register, so they're building up goodwill, they're building up that association with that word, with that image first, so that might be used while that process is ongoing, because not all words logos are able to be registered as trademarks.
Okay, cool. Again, just to the audience, if there are any other questions, we've got one coming in from Joe. That's this finger first, Joe.
Shall I answer Ali's?
Oh, we've got another one. Oh, yeah, please. Yeah. Go on. Yeah.
So I don't know if it's the TM, as in the TM, how long can you keep a TM on? In terms of a trademark can be renewed every 10 years forever. That's ongoing as long as you're paying the fees. In terms of the TM next to it, there's not a deadline that you need to remove that from. Obviously, being able to actually register and having that R on is the registration. Putting a TM on doesn't mean that is a trademark. it's almost like a warning shot, putting a beware of the dog sign at the gate, if you like, regardless of dogs or not. It doesn't do the same job, but it might be the same as you might put a see it on copyright on your website to check.
Another question from Joe. If you have worked with a supplier and do not have an NDA in place, how can you manage that?
Well, I think get some advice initially, because you could do with explaining the position. If it's still something novel that you're working on, I think you can still be looking at getting an NDA in place. I think you're able to introduce contracts at any point. You're able to explain that you've taken some advice, and off the back of that advice, you need to strengthen some of your contracts. You need to put these things in place. So that's a way of introducing. If it's the same contractor, same supplier, and you're working with something new, that's absolutely fine to introduce that. We've worked with suppliers before, and there's nothing that is new, novel. There's nothing we want to protect. But say if we're working on a particular something new, we might say to them, we need an NDA signed for this particular project that you're managing with us. Have those conversations. I really don't think, but you shouldn't be having any obstruction to that. If you're working with a supplier, and they're on the whole, you're working with people that you trust. They don't want to be taking your ideas, your IP, and going elsewhere. So verbally discuss that. Start by just saying you've had some advice, and just see how that translates. If there is a lot of opposition, I think you do wonder why wouldn't someone want to say no, they won't steal your IP?
Well, the questions are coming thick and fast now. So the next one is, if a contractor creates a design and hasn't signed over the design ownership to you, can you sell the item even if you'd paid them to create a design?
So I think you don't own the design, so that could do with being corrected. So you can go back at a later stage and ask them to assign it. This might be an oversight. This IP being assigned over may be an oversight, and this might just be a simple assignment that is fine. Sometimes there's an additional fee that someone wants and requests off the back of having that assignment over. It puts you in the best position having that, so we would advise to do it. In terms of selling the item, I don't know the contracts that you'll have signed up. You'd need to have a look at the contracts, the terms and conditions that you've signed up for this. What do those particular terms say? The main thing is it doesn't stop them from creating it or reselling the design to someone else, because they own it. They're the creator unless they've assigned it to you. So that's something to really look at.
And again, if you've got a good relationship with a designer, it's probably you're serving them by getting an NDA sorted out, so that the lines of engagement are clear for both sides. And so the likelihood is if you're the retailer, you're probably going to go up in the estimations of the designer to get that clarity in terms of how we should operate collectively.
I think if you're asked to sign an agreement, a legal agreement, an NDA, your ears prick up, don't you? That you're alerted to the fact this is serious. I need to pay attention here. I need to be clear. And sometimes that's all that's needed. We work with lots of other businesses, and lots of us work with others, and we don't intend for any slippage of IP to happen, but sometimes it just does. And I think if someone is really, crossing those T's and dotting those I's and being really tight in their contracts on the IP front, you pay attention. You sit up and pay attention, don't you? So I think it's a good process to go through.
Yeah, great.
I don't know if there's more.
We've got one being typed.
Okay.
So Joe's asked again, once work is launched, I'll say that word again, launched, how can you protect it? Unless it's a direct copy, are you protected?
So if you register a trademark, it doesn't matter how long it's been in the public domain there, you can still register. If you're looking at registering a design, it's 12 months since it's been in the public domain in terms of protecting it.
I think we're there on the questions. So the summary from today's Power Hour is as follows. Intellectual property is absolutely vital for all of the business owners within the NAJ. It gives you clear ownership and control of your assets, your brand, your trade designs, and so on. It will lead to fewer disputes with competitor businesses or people who might pass off as yourself. It gives you a stronger negotiating position should you end up in a legal space of challenging somebody else's conduct and behaviour. And it would particularly help businesses who are looking to scale and grow, that you've got the confidence of the right protections behind your business. So I'll give the final word to Michaela, where I'm delighted to say taking place at Drayton Manor on June the 2nd. So any attendees at that event can meet with Michaela and her team to discuss these matters further, and indeed they can reach out at any point. With this recording, we're going to upload it onto the NAJ platform with details by which any members can access and speak to the team from MBR. But a final word in terms of the thought you'd like to leave the audience with in terms of the value of protecting their brand name.
I think intellectual property used properly and registered certainly really supports growth. It really supports growth. And just thinking of IP, having it as part of your strategy will be helpful. If you have it in your mind when you're looking to work with new people, when you're hiring, when you're looking at new designs, how you're going to market those designs, just having it there will make sure that you're less vulnerable than you are now. Even I think the danger comes when it's ignored because you think I've got nothing to copy, I've got nothing of value yet, I'm not there. Well, success, with success comes exposure, and that's where your IP is most vulnerable.
Yeah.
So the earlier you can make those moves, the better. Thinking about it, the registrations that you can do can be really helpful, and the sooner you do them, the less anyone knows about it. So you're not as vulnerable then. It costs less, it takes less time, and it just strengthens your position going forward. We offer free consultations for NAJ members, so if anyone wants to chat with one of the team, then we can have a call and just sort of steer you in the right direction. Not every single element of registrable IP is needed for every business, but we can help on that front.
Brilliant. Well, we hope that that's been of value to the members on the call today and the audience who might view this later. And it remains for me to say thank you, Michaela, for sharing your expertise, and we look forward to people protecting their businesses going forward.
Thank you.
Thank you for joining us.